Okay, so we're gonna go to the last of the new topics, which has to do with CDCR case records, and then we'll toss it back to Mike for some quick administrative updates, and we'll be back to staff to give some other updates, and then we'll do public comment. So we're making great progress. Okay, so the last new bit of business Rick and I wanted to speak about was sentencing errors involving CDCR case records. So the way this works is when people are sentenced to prison, the court completes the most important piece of paperwork in many ways is the abstract of judgment, which sort of has what your sentence is, what you're convicted of, enhancements, and how much pre-trial credit and other things you get. That's sort of the key piece of paper that's sent to prison that CDCR takes to calculate your sentence. They have a unit there in case records called the LPU, the Legal Processing Unit, I believe, and they review every abstract of judgment. If they see what they think is an error or something illegal, or if there's some ambiguity, they send a letter back to the courts, requesting some additional information, or advising the court they may want to take a look because the sentence is unauthorized. So this can apply both if the sentence is illegally too long, like the person got sentenced to longer than they could have, given what they were convicted of, or too short, where there was sort of they weren't given enough time based on what they were convicted of. Before 2020, if a court got one of these letters, they would fix the error, regardless of how old the case was. So if that required increasing the sentence, they could do it. In 2020, there was a California Supreme Court case that wasn't quite on point, but has since been interpreted to say a court does not have jurisdiction, does not have the power just to at any time correct a sentence, even if it's unauthorized.
Well, I'm sorry, I'm not familiar. Why isn't 1172.1 solve that?
Well, it may if there's been a relevant change in sentencing law, but if there
No,
hasn't
no, no,
been,
not 600, but are these letters from case, the letters from case
no,
records
they're
are
from
not from the
case
secretary.
records. They're not from the secretary, and that's a
That's the,
key distinction.
got it.
So right. In 1172.1, any sentence change there can't be longer than the original sentence. So it wouldn't even really apply in these situations where the sentence is longer. But so there's a California Supreme Court decision in 2020 that some appellate courts said, okay, we cannot do this anymore. We can't address these old sentences. But the appellate courts themselves are split on that about what the effect of this 2020 Supreme Court decision is. And the California Supreme Court itself has denied review so far, though it kind of seems like that can't continue indefinitely because there are a number of concurring opinions, et cetera, where judges basically begging for further review. But what that means is there's confusion. People are being resentenced to higher terms. Like the case that came out a few weeks ago, the CDCR wrote the letter a week, I think, before the person was supposed to be released. The person was quickly resentenced. In fact, so fast, defense counsel said, I didn't even have time to think about this. The person got a longer sentence, appeals it. 18 months later, the appellate court says this never should have happened. But by then, that person had served the additional time, was actually released from prison. So, appellate review in the ordinary course does not seem to be a good way to fix this. And there's this split anyway. So that's sort of, I think, the most pressing problem going on with unauthorized sentence review is there's real confusion. And I think there's some injustice happening too. I mean, there are other cases where the letter came 20 years after the person was sentenced and said, by the way, your sentence should be even longer. And that just seems to violate a number of principles the committee is concerned with. And obviously what has to happen in those cases is the judge has to make a pretty big mistake. It has to go unnoticed by the prosecutor, and the prosecutor doesn't take an appeal from it. So it seems like once that happens, there should be some, the sentence is the sentence, and it shouldn't be able to be increased. Now, if the sentence is going to be shorter, I think that does present a different scenario. And there are a number of procedural vehicles, of writ of habeas corpus being sort of the most venerable and having the most Latin in the name that are available to do it. But again, you don't have counsel. And if case records has identified your sentence as being too long, it seems like we should expedite fixing that as quickly as possible. So our recommendation here is just to clarify, and I've skipped a part of the story. I'll go back since my narrative kind of took me into this idea of the unauthorized sentence first. But that if case record says your sentence is too short, the court should at any time be able to fix that and correct it without having to make the defendant jump through any other procedural hoops. But if it's too long, I think the court should. We're going to recommend the court does not then have new jurisdiction to correct it because of the problems that presents that we just talked about.
Do we
Okay,
have
so
a
that's
sense of do we sense of volume here?
I mean we know that case records has a big backlog in going through abstract of judgments. So the possibility to identify this many years after the fact is high. I don't think we know the exact number of times they identify an error or how dramatic the error is, because a lot of these letters are also, like the other issue I'm going to talk about, almost rising to the level of a typo and wouldn't necessarily affect the sentence. I don't know if there's a sense of the real big errors versus the smaller ones.
I would be curious about roughly how many letters they send to court per year.
Yeah, I think we could get that pretty easily.
Yeah.
We've spoken with them a few times. We've had a very productive relationship. So I want to make sure to mention that too, that Case Records has been great in speaking with us on top of all the other work they do. And the thing that I think is really interesting and kind of impressive about their work is none of them are lawyers, and they're looking at these very complicated sentencing issues and figuring a lot of this stuff out. And apparently better than the judges and parties in the cases sometimes. Okay, so that's the issue when unauthorized sentences. The other thing we learned is these sort of typos that we spoke about. A lot of them are just typos, like writing health and safety code instead of penal code, stuff like that. That's sort of, I think, beyond our ken. But they also told us that one of the most common errors that takes a lot of time to resolve is for when someone is convicted of burglary in the first degree with a person present. So uh, the way the burglary statutes are set up, there's burglary in the first degree, which is essentially going into a home with the intent to commit a theft or another offense. That's a serious felony under California law. A separate statute that lists the violent offenses says if you do a first degree burglary and there's a person present, we now make it a violent felony. But there is no standalone offense of first degree burglary with a person present, but it becomes violent from the addition of this other statute. And that apparently comes up enough times that it's one of the top errors that case records see, where they can't quite tell, is this a first degree burglary with a person present, meaning it should be violent, or is it just a serious version? And that obviously, that classification has a big effect on the person's experience in CDCR. So we're saying pretty easy fix for this is just to create that offense of first degree burglary with person present. Wouldn't change the elements of the law or the sentencing range, all that stuff. It would just, be an administrative necessity. Okay, so that's the recommendations. New offense to just make lessen paperwork errors, and the second one is more substantive, which to clarify courts, sort of post-conviction jurisdiction to address unauthorized sentences as identified by case records to only be available if it would decrease the sentence, not increase it. All right, I can't believe I got through that in a way. Anybody have any questions or anything about that?
I just want to say, I think you gotta be careful when you're drafting the new offense to, because when you change the code section number, if it's going to remain a serious, it's 2/3 because you're
Right.
technically adding to it. And if you don't add it to the serious, there's going to be definitely people opposing it to try to get it not be serious. So it's got to, if it's not, I mean, you just got to be it's got to be done very artfully.
Right.
So
I
that, because
I
otherwise it
appreciate that,
won't.
but just to be clear, it would be both serious and violent, the new offense.
Well, whatever, because you want to make it so it's what it is currently, but just not as confusing for CDCR. And so you're gonna have people trying to get it to get off the list. And
Right.
it might be a 2/3 if we change the code section number, because technically you're adding, and that argument could probably be made to ledge counsel. You just have to be very careful. And I can't remember how that section's drafted. It's a subdivision already within, right? Isn't it its own section within, or is it it's not? Okay, so you just have to figure out, I remember when that discussion came up and when we made it clear when it's a person, and it had to do with people wanting all burglaries to be like the higher level, and we had to negotiate
Right.
that. But I mean, it can be done. It's just not an easy draft. It's not as quick and easy draft as you think. You just have to have these things in the back of your mind when you're suggesting.
Absolutely. Yeah. Anytime those lists are, you're in the penumbra of them, it starts to get very complicated.
Yeah, and you're going to have the people who want to get rid of three strikes opposed, like there, it becomes a interesting. So you just want to be very careful when you draft it
Got it.
or when you suggest a drafting too. I mean, I think it makes sense. You just need to be clear when you draft it. This stuff gets very hairy when we've tried to
Mm,
logically separate things.
right. Which, yes. Okay. Well, that's a
Because the
great
penal
note.
code's not logical.
No. Um, okay. Well, that is the new stuff. Um, Mike, I think we can go back to you for a couple of minutes for a
Okay,
few matters.
the first thing we do is to approve the minutes from the April meeting. Um, I will move to approve the minutes.
Second.
Anybody opposed? All right, they're approved. All right. Next, I want to spend a couple of minutes, thank you, talking about CPL. We have a bit of an issue going on right now. So almost since the inception of our committee, we've been partners with the California Policy Lab. They're been extraordinarily useful to us. The relationship started when philanthropy actually paid for them to provide the empirical research that we do. And then they've been so successful that the legislature started paying for it. I don't know when, 3 years ago, Tom? 4 years ago. So almost every piece of empirical data that the committee refers to is in our reports, our presentations, the independent reports that come out have gone through CPL. They've also been informal advisors to us. They published the data dashboards, California, which is at californiaprison.data.org. And I think it's truly what sets our committee apart from policymaking committees in California and perhaps the country as to how embedded the empirical analysis is part of our work. Sadly, and unfortunately, the funding for CPL is not part of the governor's budget anymore. And the funding is set to expire at the end of next month. Now, we've been told by the good folks at CPL they're not immediately going away and turning into smoke. However, it's becoming an increasingly urgent issue. I've tried to raise it with Senator Weiner and with others, and Tom has been working on it. We've been talking to the governor's office for better part of a year about this. For what it's worth, it's less than $1 million a year. And I guess the only thing left to say is that we are working extraordinarily hard to maintain that budget level so they can continue to provide us for work. If they are unable to do it, it's going to be a serious hit to this committee. And I'm not sure what else to say. Tom, do you have any thoughts or assembly member?
I'll just say I'm happy to have the conversations directly with the budget chair, maybe even the sub chair, if it's helpful, and the speaker who appointed me to the committee. I also I think if you have like a letter, it would be helpful to have that and like maybe even get some support from folks. I think Scott and I can do it together too, given that he's
That
on
would
the
be
Senate
amazing.
side. And then I think if we can also maybe tap into philanthropy, I wonder if the governor is thinking about, this was his project and maybe doesn't want to put that on the next governor or something. Maybe he made that intentional decision. I don't know how granular he gets into budget decisions like this. So just wanted to share that it might be something for us to tap into philanthropy, knowing that we would want to get into the next governor's budget or into, making sure the next governor knows how important this is. Um, but if there's any way I can help on the philanthropy side, I'm happy to do that as well.
Thank you so much. Tom and I will reach out to you shortly. And Joanna, I just want to say on behalf of me and the whole committee, you guys have been extraordinary partners. Steve, everybody. Um, we're going to figure out a way to maintain the relationship somehow. Just you guys shouldn't have to go hungry to do it. So Thank you. All
I
right.
was just going to say, I was wondering the same thing, whether the governor doesn't want to extend beyond his term. And if that's the case, I don't know, but you might ask for a half year. So like enough to pay through January. And then if the new governor or February, and if the new governor wants to continue, then you get a budget supplement. That's all. I mean, and I'm no budget expert, but if that ends up being what the governor's argument is, I mean, the Senate or the Assembly can try to put the full funding in, but if that's the governor's thought process that he doesn't want to do funds beyond his term, just a thought.
I mean, I know everybody thinks that their project is a tiny speck of budget dust. I mean, but it's hard for me to imagine that anybody cares about this one way or another. And to have somebody who cares for it on our side, Assembly member, I think that just, might help. This is not keeping him up at night.
Good.
It's not part of his presidential platform that he has cut the Penal Code Committee's empirical research arm. All right. So I just wanted to say that. I want to say thank you. Thank you to the Assembly member, to Tom, to everybody who's been trying to maintain this relationship. It's really been extraordinary. I think when I speak to other people throughout the country, we're so light years ahead of everybody. I distribute the charts and graphs that CPL makes all the time to my colleagues at Stanford. They have no idea that this stuff is going on. And so let's do whatever we can. All right. With that said, I think we're going back to Tom for some updates.
Yes. All right. We'll move quickly. Okay, so we're going to go back to what we looked at just a month ago at the April meeting around diversion and record relief. And first, we're just go through some quick additional information that you all were interested in that we're able to do some more research on and present that. And then we'll just quickly go through the things we're thinking of, recommendations the committee should make that haven't really changed since then, and then a few other things, pending bills, crime numbers. So we'll move quick. Okay, so this first thing has to do with the number of people with mental health problems in jail. So we had a big presentation from the Legislative Analyst's Office that focused on the prison population, and you all expressed some interest in learning about jail. So what this presents here is the percentage of the daily population in jail that is identified as a mental health case. That's the classification that the folks who collect this data at the BSCC use. This goes back to 2010 and through the last summer. And we can see a very similar dynamic that we saw in the prison population was that the number of people, it's about half the people in jail now are identified as having a mental health problem. And it was 20% in 2010. And it just has steadily gone up. And now it's over half the people in jail. So again, I think this is why mental health diversion has such an important role to play in helping address this issue. And, we're particularly missing Judge Espinoza on this, who I'm sure would tell us about how dire this is in the LA County jails in particular. But this is not a problem that's limited just there, obviously. This is, statewide data. Okay, and now a little more granular information on the prison population. So you all had asked, just curious about sort of some demographic breakdowns of the mental health population. So this is all taken from what CDCR reports publicly on their offender data points dashboard. So we'll start with some racial disparities. So Black people make up 35% of the mental health population, but are only 28% of the overall prison population. So, a little disproportionality there. It's kind of the opposite dynamic for people who are identified as Hispanic and Mexican, which is they make up 47% of the CDCR population, but only 35% of the mental health population. So sort of an underrepresentation there if you think these things should be totally proportional. And as far as the male and female population goes, 64% of women are in the mental health population, while only 40% of men are. But what I found really interesting was that women are much more likely to be in triple CMS, which is the lowest level of care. So there's a higher proportion of women, but they seem to be in that much lower level of care. Whereas less men are in the mental health population, but they're receiving a higher level of care when they're in it. And obviously there's, the way more men in prison than women. So this is just proportional to their population. But that's some additional data there, just giving some more context for, I think the tremendous need for the mental health diversion program. Okay. And the last little update was additional legal research we did into appellate review of mental health diversion cases. So we had some discussion last time about, what is going on when appellate courts look at mental health diversion cases. Are they reversing them? Are they taking away diversion that's been granted? And just some concerns and whether the committee should make a recommendation on what the appellate review standards should be. So first, the appellate review standards, abuse of discretion, which in itself has like two subcategories involving whether facts are there or not. I think that's something we can get into if you all decide we want to make a recommendation here. But I think the bottom line is we looked at, and I should say it was really Joy who looked at every mental health diversion decision, published cases, unpublished cases, for 6 months and probably more than 6 months. And we only found one where a court reversed a grant of diversion. Most of these cases involve a court saying, yeah, diversion was properly denied here, or saying you should not have denied diversion. So we're not seeing appellate court sort of reaching out to take away diversion from people. So I think that led us to conclude that appellate courts, their role seems to be appropriate given what we're seeing in the outcome of the cases here. Okay, Joy, you want to give us a quick rundown of the proposals? And are you good? I know you
Sure,
had
yes, yeah, I'm
unavoidable
good.
conflict. Are you okay? All right,
Yeah,
great.
about 10 minutes or so.
Okay.
So I'm just going to run through these quickly since we were just here a few weeks ago going through these. But if anybody has any questions or comments, please do let me know. So kind of group these into two categories, the recommendations around diversion. The first is expanding to low-level felonies, which would be continuing the bill that Assemblymember Elawari, committee member, introduced last year. The second would be allowing DMV to assign points to a driver's license when vehicular manslaughter charges are resolved by misdemeanor diversion. The third would be to clarify the evidence that a court may consider for misdemeanor military diversion, because currently there's a little bit of a discrepancy, making misdemeanor a little harder to grant than felonies. The fourth would be to conduct a comprehensive study on mental health and military diversion. And I believe when we met a few weeks ago, we had talked about this study just focusing on mental health, but there is a really large overlap with military diversion, both in sort of the population as well as how the kind of the statutory language and how things play out. So we thought we would include both in this. And then the last one, recommendation around diversion, would be implementing the dissenting opinion from Justices Liu on mental health diversion, that the request may be made until sentencing. And then sort of the second group of recommendations is around record
Mike, do you have a
relief.
question?
Yeah, I'm
Oh,
sorry.
sorry.
Just
Yeah.
jump in. I want to make sure not to disturb the apple cart, because I understand there's been quite a lot of work on, is it SB or AB 46 on
AB.
AB? I would just love to keep an eye on that at least and see
Yeah.
if there's any way that we might be able to be useful, or our recommendations can be helpful there.
Sure.
All right,
Great.
that's it.
And then for record relief, the first one would be notifying new recipients of automatic record relief, since it's not built into the process that people are notified. So people are receiving record relief and they don't know about it, and vice versa. The second one is to require courts to explain why something is denied in the interest of justice. So petitioners are left sort of not knowing the basis of the denial. And the last one is just kind of harmonize all of the sealing obligations for all the types of diversion. There's different statutory language across the different types of diversion. And so there's sort of a lot of questions unresolved, and it would just make sense to make those all consistent. And then the one thing to note is when we met a few weeks ago, we did have a proposal on destroying criminal records after a certain period of time. And we're still working on that proposal. It's sort of the most complex of the recommendations, and we're still researching and talking to experts about, on certain issues of like, what does destruction actually mean? What does destruction look like? And sort of what would be the optimal waiting period for that.
All right. Okay, new proposal from staff. We just talked about Governor Newsom's involvement with setting up the committee, which he did sort of by signing legislation at the start of his first term. And now that his time as governor is going to come to an end later this year, we thought it was a good time to take stock of what the committee's been able to accomplish during the past roughly 6 years, and also to indicate those recommendations that still remain as something the legislature, the governor, or other people might take up. So basically, just a list of all the recommendations grouped by subject matter over time, because sometimes we'll look at a different topic, many times over the years, put them all together, show what's been done, what remains to be done, and then preface it all with what we expect based on the data we've seen so far to be, really extraordinarily low crime rates in California. Not to say they shouldn't be much lower. There aren't still way too many crime victims, but to put the committee to work in that context and sort of have a one-stop shop menu, perhaps for the next governor or anyone who's interested in these issues. And the reason we're bringing this up now is we'd like to, I think, get it out before the committee meets again in September, because we've got a big gap between now and the next meeting. We'd like to do it relatively soon once the official crime numbers come out from the Department of Justice, which is typically July. So this would sort of be a summer project. And our proposal would be, it's sort of cut and pasting from old reports in a way. There wouldn't really be anything new in it from a certain point of view. And that we would work with Mike to do it and finalize it and get it out, sort of like we do with the final version of the annual report every year. So just wanted to see if that was okay with the committee.
Yeah, I think this would be extraordinarily helpful, not only for committee's sake. I think it's a good time to take stock, as Tom said, hopefully for the next governor to show our value, but also I think it'd be good for us to see, to reflect back on what we've been up to, the ideas that maybe we had in the past that we have just kind of have forgotten about. In addition to tracking the crime rate, Tom, I don't know if it's possible, but along the lines of the resentencing report, is there a way that we can try to guesstimate the impact on the prison population from our recommendations?
We can try. I think it's hard because so many other recommendations involve like judicial discretion.
I know it's ambitious, but let's discuss. That would be.
Yeah. I mean, the biggest impact that's easy to quantify, I think, is the SB 43 resentencings, that we know how many people were resentenced. It's only to take a year off a lot of sentences, which is equivalent, with credits of 6 months or maybe a little bit more. But that's affected a lot of people. And if you look at, we have those numbers and even the savings to correctional cost of slightly shorter incarceration.
Sure. I'm also talking about, well, today we talked about AB 333. I know that it didn't have, a dramatic impact, but to the extent that, those enhancements went down, is there a way to calculate the change? I don't want to take too much credit, but
Yeah.
it would be good to know. Anyway, you get the point. If it's possible, it'd be great. I realize that it's very rough back of the envelope math, but.
Right.
All right.
Well, maybe we can just sort of present that and have the timeline and, at least have the correlation, if not the causation.
Great.
Okay. Well, no one else is objecting, so we'll move ahead with that.
Yeah,
Well,
thank you.
No one else is objecting. No one objected. There was no objection period.
No,
Okay.
no objection whatsoever. That would be extraordinarily helpful. Go ahead.
I'm sorry. I know I'm asking a lot of questions. Tom told me I could. I just wanted to say that I know it doesn't seem like you work on like messaging specifically, but I think it'd be really great to be thoughtful about how we take this particular next kind of report and think about what it means to put it out in the world and, like have like kind of tidbits and, bite-sized like posts, social media or whatever, or even like a press conference, like that really uplifts what you all are doing, or I guess what you're doing. I'm really proud to be a part of it. And I don't know what you're allowed and not allowed to do. So I just wanted to kind of put on like what it means for us to think about on the messaging piece. Like anecdotally, what are the stories we uplift as a result? Like, how do we also maybe use it as an opportunity to uplift Governor Newsom's work? Like, like kind of what's the word? His accomplishments or whatever, like during his tenure, but like kind of making it so that he then reposts it and it gets more traction which because he has a huge following, it might be a really good opportunity for us to think about what are the stories and messaging that we can really push out as a result of some, and maybe he's doing it already. I don't know. I just wanted to make sure I said it out loud.
No, I totally agree with it. And again, we can't take credit for even a majority of this, but to the extent that, and who knows who deserves credit for it, but in his tenure, the prison population has come down dramatically. If you combine him and Jerry Brown, the prison population has been cut in half, and the crime rates have also are at they have never been lower. So that the idea that, and this, I sort of think of this as the founding principle of this committee, is that we want to reduce, improve public safety and reduce incarceration at the same time. And we've been proving that we can do it.
I love that. Thank you. And
Yeah,
whatever ways I can help with that, I know it's like you're working with the chair, but if there's anything that I can support with on the messaging side, I'd love to lean in.
We love your help.
great. It's definitely a weakness that we have, and we're aware of it. But so I appreciate you bringing it up and offering to help.
Yeah. And maybe, I mean, I don't know, again, I don't know how it all works, but maybe we could also bring in DCO, I think the Department of Community Outreach, and like kind of bring them into the
Hmm,
fold because they do all of our like graphics on the assembly side. And so we can say, this is really important for us and we want to push this information out. And said, I don't know if you guys have mom's arm. It sounds like you don't. So like really happy to kind of see if we can utilize that mom's arm of the assembly to do it.
great. Yeah. Okay. Other update about the committees as a structure. So we are in the process of trying to hire someone to lead the committee's legislative program. The job posting is linked on the sort of front page of the committee's website. So if anyone is interested or know anyone who's interested, please spread the word. Please reach out to me if you have any questions about it. But yeah, this has been in the works for a long time, and we're eager to finally be starting the recruitment process.
Hashtag dream job.
Well, I can't disagree in this venue. Okay, so legislative update. This is very similar to what we saw in April a month ago. The suspense calendar and the Appropriations Committee was yesterday, and unfortunately, that narrowed this list a little bit. But this is what's pending now: five bills that I think implement a wide range of recommendations from the committee, and fingers crossed, we'll be able to report back in a few months that they've been signed by the governor as well.
Can you tell me what the lead bill is? The 2217?
Yeah, so the lead was essentially a pilot program that expired a
Right.
few years ago, and it would be to reauthorize that. And it's very
Just
consistent.
just for LA and San Francisco again, or?
Yeah, because it's also tied to a grant program, so it's sort of to redo a pilot, expand it a little bit. It's also, I think, tied to a budget ask, and as discussed earlier, that's probably going to be, it's just challenging for all those asks right now, but it's still pending as we speak.
Got it.
And I think it shows there's interest in it, which is great. Okay.
I also just want to say how absolutely disappointed I am that AB 2014 focused on gender bias evidence and habeas corpus did not get out of appropriations. I just want to state that for the record.
Yes, of course. I didn't want to necessarily bring it up, be the first one to bring it up as someone member. So yeah, that was very unfortunate. But we learned a lot in getting it where it was. So, if there's interest in future years, I think we'll be able to help very strongly. Okay, crime data. So I hesitate a little bit in presenting this crime data because last time I presented sort of statewide crime data for violent crime or property crime using stuff from the FBI. That hasn't been updated yet with anything new since we just met a month ago. But we do have a more limited set of jurisdictions. It's the largest cities in California, the top 7, I believe, just violent crime. It's comparing the first quarter of 2026, the first quarter of 2025, and we see a 6% decline overall, slight increase in homicide. Now, this represents, I believe, like 4 or 5 more homicides, which is, again, too many, but because homicide numbers are so low that a small number can change, percentage change, and then decreases in the other categories. Pretty similar to what we see outside of California. And then if we just, 3 of these jurisdictions are in LA County, it's the LAPD, Long Beach, and the Sheriff's Department, and we see a lesser decreases in violent crime. Again, this is just 3 months of data. It doesn't really tell us what's going to happen the rest of the year. And because it's such a short amount of time, the percentage decreases can really be overstated compared to the absolute, like actual numbers of changes. But whatever, it shows we're on a right track. And I think, it's I believe the fourth year of declines in violent crime. So it's a really great trend. And as Mike said, this isn't a California story. It's what the data shows. So hopefully we'll continue to see this. Okay. I think that's it. We can do public comment now.
Thank you, Tom. Thank you, everybody. Joy, Rick, Joanna. So we've come to the public comment time. I can't find my script, but I think everybody knows what to do. If you want to participate in public comment, please hit the raise hand function in Zoom. Once we see the number of people who want to make public comment, we'll decide how long each person has. If you're in person, please make yourself available and if you would like to make public comment. And with that said, everybody, please raise your hand if you would like to participate. I don't see any if I'm looking in the right place.
Yeah, I don't see anyone either.
Going
Great.
once. This will be the first. Going twice. All right. Thank you. Thank you, everyone. I think that this was a new format for the committee in that we didn't have the panel of stakeholders. I do occasionally like to hear from the stakeholders because, it's important. And I know that, and let me just make sure that everybody is aware that Tom, Rick, and Joy do spend an extraordinary amount of time talking to outside stakeholders. So just because they're not here doesn't mean that we're not listening and paying attention. But I do think it's kind of efficient. We got through an incredible amount of work today. So I think we should continue this, maybe not exclusively, but certainly have more of these types of meetings. Also, footnote, Tom, are we still working on the in-prison meeting?
Yes, I was going to mention that. I think that will probably make up for invited panelists, depending on how that meeting goes. Not to make up for it, but I'm anticipating, we'll have a lot more input at that. And yeah, still working with CDCR on it. Nothing final yet. Hoping to do it in September, and I'm hoping to do it in Southern California because that's where so many members of the committee are. Though maybe it's easier to get to San Quentin compared to getting across LA County, but that's a different discussion. But we're still working on it. But we hope to do it in September, and that's why we don't have an exact date for the next meeting yet. And I'll stay in touch with all of you all about the logistics of getting there and everything like that.
And as you can imagine, the logistics of holding a meeting in prison is a lot more difficult than the logistics of holding a meeting on Zoom. So thank you, everyone, for the extra work on that. That's another thing that we've been trying to do since like day one. So great. Does anything else anybody want to add for the good of the order? All right. Thank you. With that, everybody have a good weekend. Thank you very much. It's always good to see and hear from all of you. And until next time.
Thank you.
Bye-bye.